The concept of birthright citizenship in the United States, rooted in the Constitution, is now being questioned. The 14th Amendment generally establishes that being born on U.S. soil confers automatic citizenship. This principle emerged in the aftermath of the Civil War. However, there are now discussions about potentially altering this long-standing interpretation. Former President Trump has stated his intention to end birthright citizenship, raising questions about the legal and constitutional feasibility of such a change. His statements have prompted debate about the original intent of the 14th Amendment and the scope of its citizenship clause. In a recent interview, Trump reiterated his position, expressing his belief that birthright citizenship, as currently understood, is ridiculous and that it should be terminated. He has suggested that the current policy acts as an incentive for unauthorized immigration. It's important to clarify that Trump's comments should not be confused with the wet foot, dry foot policy related to Cuban migrants, which operated under different legal frameworks. To understand the current debate, it's necessary to examine the historical and legal foundations of birthright citizenship in the U.S. The history of birthright citizenship is intertwined with the legacy of slavery and racial inequality in the United States. At the nation's founding, slavery was legal in many states, leading to complex questions about the status of enslaved people and their representation in government. The Constitutional Convention of 1787 saw debates about how to count enslaved people for congressional representation. This resulted in the 3/5 Compromise, where enslaved individuals were counted as 3/5 of a person for census purposes, while Native Americans were generally excluded. Although there were free Black people in America, the 1857 Dred Scott Supreme Court decision declared that a man descended from slaves was not a citizen, regardless of his residence. This ruling underscored the racial limitations on citizenship at the time. Following the Civil War and the abolition of slavery in 1865, the legal landscape shifted dramatically. The question of citizenship for formerly enslaved people became central. Congress initially addressed this with the Civil Rights Act of 1866, which defines citizens as all persons born in the United States and not subject to any foreign power, excluding Indians not taxed. This principle was then enshrined in the 14th Amendment to the Constitution, ratified in 1868. The amendment states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." The 14th Amendment aimed to grant citizenship and equal protection under the law to formerly enslaved people. While the nation has faced ongoing struggles to fully realize racial equality, the Citizenship Clause of the 14th Amendment has, on its face, been interpreted as establishing birthright citizenship. There are, however, specific exceptions to this principle, which we will discuss further. The Supreme Court case United States v. Wong Kim Ark, decided in 1898, became a cornerstone in interpreting the 14th Amendment's Citizenship Clause. Wong Kim Ark was born in San Francisco to Chinese parents who were not U.S. citizens but were lawful residents working in the U.S. When Wong Kim Ark returned to the U.S. after a trip to China, he was denied entry on the grounds that he was not a U.S. citizen. The government argued that because his parents were not U.S. citizens, he was not subject to the jurisdiction of the United States, despite being born on U.S. soil. The Supreme Court, however, ruled in favor of Wong Kim Ark. The court determined that subject to the jurisdiction meant being under the authority and laws of the United States, which applied to Wong Kim Ark because he was residing in the U.S. and subject to its laws. The court defined very limited exceptions to birthright citizenship. These exceptions include children of diplomats, children born to foreign ambassadors or ministers who have diplomatic immunity and are not fully subject to U.S. law. Embassies are also considered functionally foreign territory. Children of invading enemy soldiers, children born to soldiers of an enemy army during a hostile occupation of U.S. territory. The court's ruling explicitly stated that the 14th Amendment's Citizenship Clause encompasses all children here born of resident aliens, with these narrow exceptions. The court emphasized that anyone domiciled in the U.S., even if a citizen or subject of another country, is under the allegiance and protection and therefore subject to the jurisdiction of the United States. Furthermore, the Indian Citizenship Act of 1924 later confirmed that Native Americans were also U.S. citizens, addressing a prior exclusion. The Wong Kim Ark decision has stood as a significant legal precedent for over a century, further affirmed by the Supreme Court in the 1982 case Plyler v. Doe. Despite the long-standing precedent of Wong Kim Ark, contemporary legal challenges to birthright citizenship have emerged. These challenges often center on reinterpreting the subject to the jurisdiction clause of the 14th Amendment. One argument, advanced by some legal scholars, suggests that the subject to the jurisdiction clause was originally intended to apply only to children of lawful permanent residents, excluding children of temporary visitors or undocumented immigrants. This interpretation argues that the broad language in Wong Kim Ark regarding resident aliens should be narrowly construed. This viewpoint gained prominence in conservative circles, particularly after a 2020 opinion piece by law professor John Eastman. Eastman argued that then-Senator Kamala Harris might not be eligible for the presidency because her parents were not U.S. citizens or lawful permanent residents at the time of her birth. His theory was widely criticized as legally unsound and racially motivated, echoing earlier birther claims about President Obama. Eastman, who has long opposed birthright citizenship, has argued that Wong Kim Ark was wrongly decided and that its precedent should be disregarded. He has also raised national security concerns, suggesting that birthright citizenship could be exploited by those seeking to harm the U.S. Furthermore, some legal arguments, particularly in the context of Texas's border policies, have invoked the actual invasion clause of the Constitution, Article 1, Section 10, Clause 3. This clause allows states to engage in actions normally reserved for the federal government, such as war, if actually invaded. Texas Governor Greg Abbott has declared an invasion at the border, arguing that this justifies the state in taking actions to defend and protect itself, potentially even overriding federal law. This argument, supported by some legal figures like Judge James Ho of the Fifth Circuit Court of Appeals, proposes that undocumented immigration constitutes an invasion, which could have implications for the application of birthright citizenship to children born to undocumented immigrants. Judge Ho has suggested that a governor's or president's determination of an invasion might be non-reviewable by courts. President Trump has announced plans to issue an executive order aimed at ending birthright citizenship for children born to unauthorized immigrants. While the specifics of such an order are not fully detailed, it is anticipated to direct federal agencies to alter their interpretation of the 14th Amendment's Citizenship Clause. Potential actions could include instructing the Social Security Administration to deny Social Security numbers to newborns of undocumented immigrants and directing the State Department to refuse passports to these children. It is also possible that states, like Texas, might begin issuing birth certificates that differentiate between citizens and non-citizens at birth based on parental immigration status. Such actions would almost certainly face immediate legal challenges. Courts would likely be asked to issue injunctions to prevent the implementation of these policies until a final legal determination is made, potentially by the Supreme Court. The legal outcome of these challenges is uncertain. While there is over a century of Supreme Court precedent supporting birthright citizenship, the current composition of the Supreme Court and the differing legal interpretations presented create a degree of unpredictability. Furthermore, it is important to note that discussions have also included the possibility of deporting U.S.-born children of undocumented immigrants along with their parents, raising further legal and ethical questions. Ultimately, the future of birthright citizenship in the U.S. remains a subject of ongoing legal and political debate. The extent to which existing legal precedents will be upheld or reinterpreted by the courts will determine the long-term impact of these challenges.